So good afternoon, everybody. We're pleased to welcome you to what I think is the 7th class session of Democracy and Disagreement. I'm Paul Brest, and along with Deborah Satz, who's at an academic conference today, I'm the faculty lead for this course. Graham Ambrose is the TA for the course. You've heard this before, but go through it again. Each of our 10 classes addresses a contemporary issue of policy about which people hold strong differing views. Each class has two immediate goals: to illuminate these issues and to do so by modeling the critical, empirically informed, respectful conversations that lies at the core of the university's mission, the pursuit of knowledge. We also hope to shed light in the course on why some degree of disagreement is inevitable in a democratic society. Only dictatorships produce an outward appearance of conformity and unanimity on a wide range of issues. Yet while disagreement is a feature and not a bug of democracy, it's hard, especially hard when the stakes of disagreement are high. The first part of today's class will be devoted to such a difficult issue, today on the question of whether the government can impose non-discrimination obligations on how platforms treat user-generated content. During the second part of the class, you'll have a chance to ask questions and make comments, not speeches, but comments that are appropriate to furthering the class discussion. Of course, if you hear something about which you disagree, you are allowed, in fact, you're encouraged to ask difficult questions of our speakers during the Q&A. We recognize that engaging in respectful conversation is only one mode of bringing one's case to one's peers. Protests and organizing are also legitimate modes of engagement, although subject to time, place, and manner restrictions. For anyone who feels motivated to protest the class or our particular speakers or moderator, or to make a long speech, there is a free speech zone outside the classroom for doing so. Before I introduce today's topics and speakers, if you're a student enrolled in the course, would you please scan the QR code on the screen and fill out the Google form for attendance? I'll give you a minute to do that. So as mentioned, today's topic is, may the government impose non-discrimination obligations on how platforms treat user-generated content? We're very fortunate to have two knowledgeable speakers, two knowledgeable and thoughtful participants to discuss the issue, and also an expert in the field to moderate the issue. Zephyr Teachout is a professor of law at Fordham Law School, where she focuses on the intersection of corporate power and political power. She teaches corporations, election law, antitrust, and prosecuting white-collar crime. Her most recent book, Break 'em Up, makes the case for reimagining the relationship between democracy and anti-monopoly law. Before law school, Professor Teachout was a digital consultant and nonprofit entrepreneur, and also represented clients on death row in North Carolina. She holds a BA from Yale and a JD and MA in political science from Duke. Aaron Mackey is an attorney with the Electronic Frontier Foundation, where he litigates free speech, anonymity, privacy, government surveillance, and transparency cases. Before joining EFF in 2015, he worked on speech, privacy, and freedom of information issues at the Reporters Committee for Freedom of the Press and the Institute for Public Representation at Georgetown Law School. He has a JD from Berkeley and an LLM from Georgetown Law and an undergraduate degree in journalism and English from the University of Arizona. Our moderator is my colleague Evelyn Dueck, an assistant professor here at Stanford Law School. Before coming to Stanford, she was a senior research fellow at the Knight First Amendment Institute at Columbia University. After graduating from the University of New South Wales with a Bachelor of Commerce and Laws in 2013, Professor Dueck served as a law clerk to Chief Justice Susan Kiefel of the High Court of Australia and did a short stint at two commercial litigation firms in Sydney. She obtained a doctorate from Harvard Law School on the topic of private and public regulation of online speech. We imagine that each of the speakers will talk for about 10 minutes and then converse until around 4:15. Professor Dueck has to leave to teach a class around 4, but I will then assume the task of moderator. And then the floor will be open for questions or comments from the audience. And we're going to survey the class as before at the beginning and end of each class to see whether the arguments move minds. That said, even when minds are not moved, we hope the class gives you an appreciation for the reasoning behind views you hold, as well as those that you reject. So here again is the question we're posing for today. Can the government impose non-discrimination obligations on how platforms treat user-generated content? And you now you are welcome to enter your comments on the poll. Graham will gather them. And are you able to show them on the screen? Can you read them, Graham?
It's 67 for yes, 30. It's moving. It's about 2/3 for yes, 1/3 for no currently.
Okay, let's remember that when we do the polling afterwards. And now, Evelyn, thank you for taking over the moderation.
Great. Well, thank you very much for the introduction, and thank you everyone for having us here today. I'm very excited to be here, and when I have to slip out at 4 o'clock, please don't take that as any sign of my lack of enthusiasm. I have to head off and teach a class at the law school, and in fact, the class that I'm teaching today is covering exactly the issues that we'll be talking about for the next hour, so this is excellent prep time. The topic that we're talking about today, the question that you just got asked, in some sense is deceptively simple. Can the government impose non-discrimination norms on how platforms treat user-generated content? And this is all coming to a head now because 2 states have tried to do some version of exactly that. So in some sense, the question that we're talking about today is whether the laws passed by Texas and Florida that regulate social platforms, how we should think about those and whether they should be upheld by the Supreme Court when it hands down its decision on their constitutionality in the coming weeks. And oral argument was heard a couple of months ago now, and we are all on the edge of our seats waiting for that one to come down. Now, I say this question is deceptively simple because the laws themselves are complicated and they throw up lots of different issues, and also because a lot of the debate around these laws comes down to how even to frame the question. And we, as a panel, indeed debated quite vigorously how to frame the question for you when we asked it today, because how to even describe what exactly the issue here is the matter of some contention. So let me describe the laws first and then talk about how the framing differs from different perspectives. So at the simplest level, what the Texas and Florida laws do is they place restrictions on how social media platforms do what is commonly known as content moderation, or as we put in the question, how they treat user-generated content. Now, social media platforms, as I'm sure all of you probably know, have certain rules about what you can and can't post on their sites, and they take down the posts of users that violate those rules. And they do that a lot. In fact, during the time that we're sitting here in this room today and talking about it, Facebook alone will take down over 1 million posts. So this is something that they do a lot of, and that is an awesome amount of power. This thing that the platforms are doing in how they decide what rules they set and how they enforce those rules shapes the way that we talk about matters of public concern. It shapes public debate. It affects a lot of politics. It affects our public sphere in fundamental ways. That's a huge amount of power. And Texas and Florida, in their laws, are seeking to constrain that power in various ways. They do this slightly differently, and for our purposes today, it's not important to get into the details. At a high level, Florida's law prevents platforms from taking down content posted by so-called journalistic enterprises or content by or about political candidates. And it also requires that content moderation be carried out, quote-unquote, consistently. Texas's law, meanwhile, says that platforms cannot engage in viewpoint discrimination in how they deal with user-generated content. Now, you might sometimes hear these called must-carry laws because in some way they, in practice, require platforms to carry or to not take down content that they otherwise might. Now, this is where things get complicated because the parties to these cases frame these issues completely differently. And indeed, the lower courts that looked at each of these laws also framed these questions completely differently. So the platforms and the 11th Circuit, on the one hand, said that this kind of content moderation, when platforms write and enforce their rules, that's essentially editorial discretion. Just like the New York Times, when it decides what it's putting on its front page, that's editorial discretion, and that is exactly what platforms are doing when they choose what appears on their sites or in your newsfeed. And that kind of discretion to pick and choose and arrange user-generated content is protected by the First Amendment. It's a kind of speech right that is protected under the Constitution. Now, the states in these cases, and the Fifth Circuit, on the other hand, said no, what the platforms are doing is not speech, it's a kind of conduct. The Fifth Circuit said it's not speech, it's actually censorship when they take things down. And they say that these laws, the Texas law, doesn't limit the speech of platforms. Instead, it protects the speech of the platform's users, and that it protects that speech against the arbitrary power of tech companies. So on the one hand, you've got a focus on the speech rights of the tech companies in moderating content, and on the other hand, you've got this focus on the speech rights of the users in posting on these sites. So who is right? Or is neither view? Is the answer something in between? That's what we're going to be talking about today. That's what the Supreme Court has been thinking about, I'm sure, non-stop. They've got nothing else to think about at the moment for the last few months, nothing else on their plate at all. And so that's the contours of our debate. And while our conversation is sort of why I've framed this conversation as a conversation about Texas and Florida's laws, it's actually much broader than that, because this is a question about how the First Amendment should work in the age of online platforms. Because on the one hand, if the First Amendment is meant to protect against anything, it's meant to protect against state interference in the marketplace of ideas. It's meant to prevent against the government interfering with what you and I can say in the public sphere. But on the other hand, we now have these enormously powerful companies that shape our public sphere with little constraint or accountability, and little transparency into how they are even performing this task, which also seems, in some sense, to me, also deeply unsatisfactory. So these cases are about how and who should set the rules of the road for online speech going forward. And that's what our two panelists are going to be talking about today. And so I'm going to hand it over to Aaron, who is on the no side of the question that you answered.
Thanks, Evelyn, and thank you, Paul, for having me. So if you don't know about the Electronic Frontier Foundation, it's a nonprofit based in San Francisco that was founded basically to defend civil liberties in the digital world. So our mission is to ensure that technology supports freedom, justice, and innovation for all the people of the world. And so what's particularly relevant here, a big part of our work is fighting for and defending internet users' rights to speak, to share online, to organize. And so one of the reasons why we come at this on the no side is, I think, sometimes a little bit counterintuitive, because as Evelyn said, right, the platforms, the major platforms that we use have outsized power. They exercise it often arbitrarily. They can be sort of vexing in sort of the decisions that they make about any piece of user-generated content. Their content policies are often sort of incomprehensible. And when a piece of your content is removed, you might have very little recourse to even understand why, let alone to challenge it, right? And so that is a legitimate concern, and one that harms users, because that does inhibit people's ability to share and speak online. But from where we sit in terms of who should be the ones to decide, we're of the view that users are best served on balance when it's the platforms that are making these decisions and not the government. And the way we think about that is because we think that there are much more benefits when it is the platforms who are exercising those decisions and making them, both in terms of the platforms are able to make choices about the types of content that they host. And so that includes everything from wanting to be the biggest platform serving billions of people in the world, to wanting to be a community that serves something as niche as being a place for knitting. right? So if you're a knitter, you can go to Ravelry. Also, if you are big into discussing veganism, there are vegan forums. If you are big into discussing smoked meats, there are smoked meats barbecue forums. There are forums for people who have certain political views, certain backgrounds. So if you're in the military, there are social media services and support services for you and your family. And all that is enabled because the platform gets to make the choice about the type of content. And that includes making choices about excluding certain content, right? So the vegan forum, I think, reasonably decides that we can discuss veganism, but we're not going to sort of have the forum be overtaken by people who are just anti-veganism. And the same thing holds true for a conservative platform that says, we'll have debates about conservative principles, but we're not going to sit here and let someone from a liberal ideology just sort of take over our service, because we're fostering a community here where we have discussions based on the rules that we've set. So that's one benefit. Another benefit is actually we see the diversity in the types of services, the actual content moderation, or how, framed in the question here, how the platforms actually deal with user-generated content. So we're all familiar with the sort of top-down model where Facebook sets the terms, and if you don't comply, right, your information is removed. But there are other models, right? And we see the most, the most obvious alternative model is something like what Reddit and Discord employ, which is a community-driven moderation system. So while there might be an overarching content policy on sites like Reddit, the subreddits themselves are actually governed by a set of community moderators. They set their own terms, and so they buy in. If you go to those systems, both the users themselves are subject to those terms, but then the enforcement is actually done by the community itself. So it's a little bit, it's not quite bottom up, but it's a little bit more mediated by people in the middle as opposed to being top down. There are also other models that involve things that are lighter touch, right? So voting things up, voting things down. Those types of tools are also available. And we think those benefit users because they're able to actually find places where they have community. And you're also able to basically have the place where you might be able to reach an audience that thinks like you, or that are able to maybe sort of enjoy the presence of content that you enjoy and that others enjoy. So, I think when it comes to other parts of the sort of Florida laws, there are issues around like transparency and whether you can enforce transparency on platforms. I think from EFF's perspective, I think it's a really interesting question about where the government can actually intervene and say, what is required for a platform to actually say about its content moderation choices. So I think we would sort of maybe fall on the, not the yes, no, but the maybe of the questions. But one of the things that we see is like a pitfall with these voluntary efforts is I think they're often written with the idea that the internet looks like the Facebook and the YouTube, when in fact the internet looks a lot different to a lot of different people. And so these regulations might not scale or actually fit a lot of the content moderation services or the needs of particular communities. And I think also, as we've seen, at least in the Florida law, the purpose behind sort of ensuring transparency is not a good faith basis of actually informing consumers, but it's actually sort of in retaliation for the ways in which platforms have, at least the perception is by these lawmakers, have misused their ability or their authority to censor user speech. So when it comes to internet regulation, we're sort of not an outright no, but generally what we ask are things like, what is this law trying to accomplish? Is it necessary, and also is it going to be effective? And then related to that is, will courts uphold these laws? Do they actually have a chance of being enforced and implemented because of these underlying First Amendment concerns? And then more generally, will it cause collateral damage? So again, like EFF is, I think, rightly sort of perceived as being on the no side, but we're not on the never side. And so I think what's important to understand is that we don't believe that online services can never be regulated, right? So regulations that don't target the choices that platforms are making, right? This is sort of editorial discretion. about how they host and promote content. Those laws we look at, and generally we try to think very clearly about that they have the opportunity to actually make an impact, right? The other things that we think about are there are a lot of ways to address a lot of different online harms that don't actually have to do with content. And so that can be things like addressing consumer privacy, so stopping the flow of personal data that actually infects a lot of the targeting, both on the ad side as well as things that the reasons why it ends up in your newsfeed, certain content ends up in your newsfeed. So if we put restrictions at the outset about how much information is collected, we might have an opportunity there to prevent some of those harms. Big work on doing greater antitrust and competition enforcement. I think Zephyr and I, one of the things I think we strongly agree about is that we do think that the government has a stronger role to work on removing a lot of the sort of artifice that has been evolved by basically having like 5 companies decide what's seen on the majority of our websites and services on the internet. And then lastly, we also think that Congress should play a role, or lawmakers should play a role in removing a lot of the roadblocks to that have moved us farther away from the original idea of the internet, which was that users had control and empowerment over the internet that they saw, and being able to actually interact with the internet in a way that they could customize their own services. So this deals with things like allowing someone to have a third party that actually interoperates with Facebook or with X, where you can control your feed, you can filter out things, and you can also do things like have your feed be more transparent, right? Have it tell you why Facebook is delivering you a particular piece of content, or tell researchers why so they can understand it. So we see those as really viable alternatives that don't lead us down into the thicket of this sort of First Amendment morass that we're currently in.
Great. Zephyr, over to you.
Hi, thank you so much. I don't have a sense. Am I some looming screen there?
Yeah, you're really, really big. Yeah. So very intimidating. It's an awesome force. Yeah. Natural advantage.
Thank you so much for inviting me. Thank you so much, Paul and Evelyn, for moderating. And it's great to see Aaron in this Democracy and Disagreement. A few weeks before we were invited to do this, we were doing a private forum on another topic of a robust disagreement. So I appreciate the chance to continue this conversation here. Because of the way the audio worked, I didn't actually hear my own introduction, so I'm going to share a few facts about myself that may help you understand where I'm coming from on this issue, which I care very deeply about. I'm a lawyer. I'm currently a law professor. I started out my career representing people on death row in North Carolina. And in that work came to be horrified by the gross inequities in our societies and the way in which those without money were treated entirely differently. The ways in which race, geography, and poverty all interacted to create profound inequities, even in a moment like execution and death. Since then, I have spent most of my career in various ways, certainly as an academic, but also as an activist, working against corporate power and the ways in which corporate power has come to shape far too much of our democracy, laws, and society. And in that realm, in my lifetime, we have seen a grotesque, in my view, expansion of corporate power through the vehicle of this thing that we may think of as quite precious and beautiful, the First Amendment. Long before I was a lawyer, I was maybe 5, the Supreme Court in 1976 really started down this path of granting commercial speech rights, of using the First Amendment and giving corporations the capacity to use the First Amendment as a real sword against publicly passed legislation. In that case, it was legislation concerning advertising for pharmaceutical companies. Since most of you probably spend more time on Instagram and TikTok than TV. You may not know this, but that 1976 loss has led to today's life on television, where you see constant pharmaceutical advertising on television. But it's obviously not just that. There's been a series of Supreme Court cases where corporations have challenged publicly passed laws, some of which are stupid, some of which are amazing, and said, we have First Amendment rights. Either we have them directly or we have them indirectly because the public has a right to hear what we are saying. The one that you probably are most familiar with is Citizens United. And I was very active in trying to stop Citizens United before it happened. Totally failed on that one, but was cited extensively in Justice Stevens' dissent. In that decision, the Supreme Court held, among other things, that because the public has a right to hear the great variety of any kind of expressions, whatever the source, the public could not pass restrictions on corporate spending in elections. We're 14 years into the Citizens United decision, and it has transformed elections in this country, with corporations, super PACs, playing a far more significant role than they did 15 years ago. I won't tell you it was beautiful 15 years ago, but it's a lot worse now. So I just want to give that as a part of the context, because when we're talking about the question today, can states, can the government, can the federal government pass non-discrimination rules? The real question we're asking is, should the Supreme Court strike down publicly passed laws using the First Amendment? And we can drill down on that. But I see this question as part of a series of these cases since 1976. And the reason I care so deeply about this is because we are facing one of the greatest policy challenges, a really hard policy challenge. What do we do about big social media companies? And I do not want to see the Supreme Court step in and basically cut off the ability of the public to grapple with that. Sometimes for ill, sometimes for good. I have a lot of ideas about laws we should pass, but if the Supreme Court cuts off the capacity of New York State, where I live, the federal government, to actively engage in this really difficult challenge of mass social media companies, I think we are then really leading towards being governed by these big social media companies and not governing them. And that's a form of corporate governance that, to my mind, approaches tyranny. So what's the puzzle? The puzzle is that we have, in this class, I wish I could see you. I couldn't come because I have a small child, but I love being in the class and being able to sort of see you shaking your heads or nodding or whatever. But I will imagine you, and I imagine that if you are like many students today, you have had your life pretty profoundly shaped by social media. You probably spent more time using social media when you were 16 than you did talking to your parents on any given day. And that's an understatement. So we're talking about Instagram, TikTok, other big social media companies with reach of over 150 million American users, and the power to totally reshape how we think, how we connect, what we do, what we prefer, the content of our heads and the content of our conversations. So the Markup and other organizations have done research showing the ways in which these social media companies, which say that we're open to the public, in fact, express strong political views. For instance, there is pretty good evidence, both by Human Rights Watch and the Markup, that Palestinian views are suppressed on Instagram. evidence that the sharing of flag emojis, those who share flag emojis, they may share it. I don't know if you guys have talked about shadow banning, but when you yourself see the content but nobody else sees it, it's a debated term that Evelyn probably has a lot to say about, but ways in which the speech is suppressed based on a political viewpoint. There is evidence that abortion-related posts have been suppressed in a systematic way. That images of war were suppressed in a systematic way. That there are different treatments of different political views. Now, there's some who have found evidence that Trump versus Biden, Trump-related posts were more likely to be shared than Biden-related posts. Those who are concerned about those on the right who will often point to evidence of platforms demoting content, being skeptical of vaccines. These are areas where we already kind of know that there is a political, very clear thumb on the scale. If states and the federal government are not allowed to pass non-discrimination laws of various kinds, and we can talk about the various kinds, we expect to see this and far more, and we know far more is going on. There's a black box here. But just to give you a few examples, in the 1870s, a presidential election may or may not have been thrown by the owners of a telegraph company. The owners of central communications infrastructure, who have no limits on how they can use that infrastructure, have the opportunity and ability to throw elections, suppress perspectives, not on maybe the issues that you're thinking about all the time, but issues that directly concern them, like taxation of social media companies, antitrust laws, direct content that directly impacts them. So this is the challenge. We have this communications infrastructure with the power and capacity to, on a micro and macro level, direct speech in this country. And I hope that the Supreme Court, in the cases that we are, yes, all on the edge of our seats, recognizes that right now, right as we are beginning to see the scope of the problem, is not the time to basically remove public power from policymaking. When about 14 years ago, the Supreme Court shut down, said there's a Second Amendment right to handguns, cities and states can't pass handgun laws, they've interrupted public efforts to deal with a very significant public health crisis. And if the Supreme Court now says, no, you can't, there's this can in the question here, you can't pass non-discrimination laws, that is basically interrupting a central power of states and the federal government to try to do something about this tyrannical centralized power that we're seeing in just a handful of social media companies. We can get more into the weeds, but thanks again for having me.
Okay, great. So that's a really helpful way to set the stage. I guess I have a question for each of you. So I'll start first, Aaron, to get you to respond to this point that Zephyr's making about the power of these companies and why we shouldn't be worried about that. In some sense, another way to, how can you be against non-discrimination? I feel like the question in some sense loaded it. No wonder a lot of people yes, who wants to say, yes, let's have discrimination? Non-discrimination sounds good. And in your opening remarks, I heard you talk a lot about the benefits of these companies for users, the benefits of a vibrant marketplace or all these different things. But why should we be worried about non-discrimination? I take your point about Vegan Forum, for example. As a vegan, I don't want them to have meat lovers invasion on the Vegan Forum. I respect their right. But what about these big companies that say we are open to the public? We are the new public square. This is where we discuss the ideas of the day. why shouldn't we be worried if they are maybe slanting the debate one way or the other? The background for the Texas and Florida laws is this concern coming from these states about the idea that these platforms were suppressing conservative speech. Now, there's no particular evidence that that is the case, but if that was the case, that might be something that would be problematic if they are slanting political debate in this country surreptitiously without transparency in one way or the other. Or another way to put it, this moment in the oral argument in the Fifth Circuit where one of the judges asked the lawyers for the platforms, so Twitter could tomorrow snap its fingers and remove all LGBT content from its platform. Is that what you're saying? And the lawyer for the platforms had to say, yes. The natural conclusion of my argument is that yes, I can remove all LGBT content from my platform tomorrow. Why isn't that a problem?
Yeah. So I think I'll start with your easier question before getting into the non-discrimination one. So the easier question was like, why should we not be concerned about this massive power? So Zephyr and I agree and share a concern about the power that these platforms have to shape our public views. We disagree on the intervention, right? We disagree on how the law might intervene. But there's I just want to be clear, right? EFF totally agrees that it's a problem that 5 or 6 online services have an outsized role in the most predominating forum of our lifetime. Now, why is non-discrimination a problem, right? Why shouldn't there be a law that says Twitter, you can't just snap your fingers and remove all of this content on a particular topic like LGBTQIA? And the reason is the conclusion of that argument, that is, if the state can pass a law that says, or the government can pass a law that says no platform can sort of moderate that content, can remove it, then that means that the law has to be sort of subject to this idea that we should devote equal time to all, so we should not just discriminate against the views and content, the viewpoints and content and causes that I agree with, but we can't discriminate against those views and content that I disagree with, right? So that means Twitter can't also moderate pro-Nazi content. It can't moderate or help individuals who are LGBTQIA who are targeted with violent rhetoric and harassment online. And so the hard thing is, how do you design an intervention that protects your preferences for the world that you would like to see online, while also preventing against the sort of harm from that non-discrimination rule? So it's really hard in the context of the First Amendment to pass a law that says we're going to the government's going to put its thumb down on the scale of certain types of content, maybe prohibit it or maybe boost some content at the expense of others. We won't get into the exact doctrinal basis, but it's just a very hard test. And so I think, how do you design that rule? I think an interesting question or a topic to think about is, can you set separate rules? So can we have a rule that does allow the vegan forum to exclude? But we say Facebook, or say if you reach over 100 million active monthly users in the United States, can you design a different, is the rationale different? Is the government intervention and interest different there? And I think there are some really interesting questions about whether something like that might be possible.
Okay, Zephyr, so to turn the table then, why aren't you more concerned about government interference, right? Like when I teach First Amendment law, we talk a lot about how the First Amendment, if it, is about protecting against the government from interfering in the marketplace of ideas. And, you opened your remarks by talking about how your background is about the concern of how laws fall most harshly on the least powerful in society, and often those the least well-resourced, those who are otherwise subject to discrimination. And the history of the First Amendment law and speech enforcement often is that story too, right? Is that when you have laws against certain kinds of speech, the people that they get enforced against are often the least powerful. You mentioned, for example, concern about pro-Palestinian voices being suppressed on certain social media platforms. And it's not obvious to me that more government intervention in the way platforms are regulated would be more solicitous of pro-Palestinian voices in those spheres. So why shouldn't we be more concerned about giving the power to the government to say when and how a platform is regulating, is discriminating, or isn't being quote unquote consistent, and the power that gives to the government to shape our marketplace of ideas, and the obvious bad incentive problems there, right? Because the government has a horse in the race for political debate, like it wants political debate to go in its favor, and so the government having that power is also very scary.
Yeah, thanks. Great question. I'm deeply concerned about government abuses. Deeply concerned. A slight reframing, and then I'll explain more fully. What we're talking about is different forms of government. So when we talk about the Supreme Court, that of course is also part of the government. And one of the key differences we have here is I do not think of the Supreme Court as a good decision maker, good at making these balancing decisions. I do not want the Supreme Court to be engaged in the kind of precise analysis that Aaron was talking about, not just because it is this Supreme Court that struck down the Voting Rights Act, this Supreme Court that is particularly solicitous of corporate power, this Supreme Court that is doubling down on Citizens United, but because the institution of a court, these sort of 9 justices, I think has very rarely, except for brief moments in American history, brief extraordinary moments, but very rarely been democracy enhancing. So I return to that because I do think the question of these institutions is really core. What we are talking about here is a very particular kind of government intervention. And I appreciate the opportunity to explain why non-discrimination rules are a very specific and important kind of government intervention. So a non-discrimination rule is like, what does that mean? So there's 2 basic categories that you probably already have in your head, but they don't necessarily fit together. I'm going to suggest maybe we see them as a little closer. One is the non-discrimination rules that you may not even realize that you benefit from all the time, but non-discrimination rules like your telephone company can't cut you off because you're talking about abortion. Since the 1880s, the big trust busters, the first move of the trust busters was not breaking up railroads. It was passing non-discrimination rules so that railroads couldn't treat different farmers differently because they were using the capacity to treat different farmers differently to exploit them. When we've had centralized infrastructure, whether it's the telephone that you're used to, being able to have your conversations without being edited by your phone company, or the telegraph, or railroads, or more recently, again, and then not again, and then again, network neutrality, the push to have neutrality on for broadband so that you can't actually have speech suppression based on your viewpoint. Non-discrimination rules have been really critical in taking in the state passing a non-discrimination rule, but that isn't putting a thumb on the scale. It's basically removing the ability of this centralized power to put a thumb on the scale. And so unlike the government acting to prefer one kind of speech over another, this kind of law has a special power and one that I think is increasingly important. And I filed a brief in support, not in support of the Texas and Florida laws, which frankly are a mess in all kinds of ways, but in support of the power of states to pass non-discrimination laws. I talked about the ways in which non-discrimination laws are increasingly important in the employment context. Uber drivers losing their job because of a policy perspective. New York City, where I live, has non-discrimination rules in the employment context, saying you can't get fired for have viewpoint non-discrimination rules. I just want to start to think, I know I was going to add together. Then there's non-discrimination rules that you're familiar with on the series of protected classes where it is particularly important to pass non-discrimination rules, especially race, that apply not just for centralized infrastructure, but across the board. So all of these non-discrimination rules are democracy. They tend towards democracy enhancing and away from the government putting the thumb on the scale. And I think it's particularly important that this court not take away the power to pass non-discrimination rules. To give one example, we're talking about user content. Think about different news organizations and the power of, let's just use Meta to treat those news organizations differently. There's a federal bill, which I support. I think EFF opposes, I'm not sure. Well, I won't speak to you as EFF, Aaron. I will speak to you as a storied, experienced First Amendment lawyer, former journalist. But I have talked with and worked with various journalist organizations that are supporting a bill that would forbid big platforms from treating different news organizations differently. Because part of the reason that Meta doesn't have to pay them anything is that they can treat them differently and play them against each other, just like the railroads did with the farmers in the 1880s. If the Supreme Court says, oh, what Meta's doing when it's making these decisions, it can't be subject to a non-discrimination regime, that means that we can't even pass rules saying that they can't discriminate between different journalist organizations. So the implications of this are enormous. And while I agree completely with Aaron, this is where we do agree very deeply. I think the policy questions are really hard. I think the question of the right way to write a law that protects the vegan knitters. Sorry, I put you all together. I don't think that's easy, right? I'm not getting emotional. I am emotional, but just have I don't want to take the power to imagine those solutions away from the public. And I fear that a Supreme Court action does just that.
So yeah, Aaron, it's true that my phone company can't cut me off if I start talking about abortion, and that seems like a good thing. It's also true that currently, the New York Times could write an article that's extremely critical of Mark Zuckerberg or Meta or Facebook, and then Meta could decide, well, we don't like that very much. We're going to downrank all New York Times stories in our users' feeds for the next, however long, forever. Forever. And there's nothing anyone can say about that. Why isn't that a problem for democracy, that these companies can do that?
I think it is a problem for democracy. I think the danger is when the intervention is that we're going to treat you and I and the New York Times speech as being the same thing as goods that are shipped via rail, or the conduct of giving you a phone line, right? Giving you an interface to communicate, not actually regulating the content itself. I think there's a dangerous slip that we move to a world in which the government has a more outsized role in what we can say and do online than the platforms do. And so it is, again, just to reiterate, like 100% agree that there's a big problem if Meta can essentially suppress critical news of itself on its platform. I don't think that the intervention is to pass a law that says the Meta must treat every journalistic organization the same. And so we can quibble about what this looks like, and this is unfair for Zephyr because this is not what she's arguing, but the bill in Florida defined what a news organization was so broadly that it included YouTube channels like CoComelon. So if any of you have small children and have ever experienced CoComelon, it's just an endless run of CGI lullabies, and it's awful. But they qualified as a platform, and so a YouTube couldn't say do anything with CoComelon's site because it was treated the same as the New York Times or the Wall Street Journal. And so there's both a problem generally about how we make those interventions, and then specifically about what that actually looks like and how, when the rubber meets the road with what the lawmakers write, who are we actually protecting, and what are we trying to do here? So again, I think the solution to something like Meta being able to put its thumb on suppressing speech is to make sure that Meta doesn't have billions of users, and that the only way you can ever interact with those billions of users is to be bound by Meta's terms, or to be sort of bound up in the sort of Meta triumvirate, right, of Facebook, Instagram, WhatsApp. Like, that's what we need to be addressing, is how do we actually stop that? So one, we break them up, right? We move to sort of deconsolidate all that power. And again, we create tools, whether that's via antitrust enforcement, new competition laws, that enable you to communicate on Meta with your friends and to take your social network with you, and so that you can interoperate, but you don't have to play by Meta's rules in some ways. And then also we remove the legal barriers, things like the Computer Fraud and Abuse Act and the Digital Millennium Copyright Act, that inhibit us from having intermediaries who can actually help us navigate both our interactions on social media broadly, but also so that we can make better choices about what we see on social media. So I think all of those interventions don't put us in a role or world where the government has an outsized power or role.
Can I directly respond?
Yeah, I think you're up.
All right. I mean, Aaron, I feel like you're living in a fantasy world, and with all due respect, but like, the way to get to a world where we can actually talk about some of those solutions is not to cut off some of the key policy solutions or go running to the Supreme Court to say, please stop this law that I don't want. One of the most powerful briefs in this case, I thought, was from Attorney General Tish James, who I used to work for. So if that's considered a conflict, that I think she's great, so be it. But Tish James and several attorneys general from progressive states. They basically filed for neither party, which is a way where you can say, listen to us, but we're not going to tell you what to do with the law. And what they said is, be careful, because if you find that there is a First Amendment right that means that you can't pass non-discrimination laws, here's 60 state laws that we are either working on or have just passed that are addressing the problems we have today with these big tech companies, the problems that we haven't talked about it yet, but the problems that are happening today with targeted algorithms impacting the mental health of teenagers, the problems we are having today with discrimination. Do not act in a way right now telling us someday, 30 years down the line, we're going to be able to address it. Allow us the freedom to do this. Now, to be clear, we're not saying the state should be able to to force a point of view on these platforms. I don't think they should at all. We're saying that the state, one area where the state can get involved, and I said put a thumb on the scale, but it's like take the boot off the neck of this democracy. Right now we have the scale and scope of communications power is truly unheard of. We have never had, it's like, I sometimes think, like, if all our cars and buses were, did you guys ever see or read Wrinkle in Time. All our cars and buses were coordinated. Like every method we have of getting from one place to another had the same message and the same profit motive and the same owner. We have never had this level of centralized power. And I don't think the right place to have the debate on good and bad policy, where Aaron and I are going to agree on maybe 70%, maybe not on 30. But I don't think the right place to have that debate is with Justice Alito. The right place to have that debate, and it's hard and it's ugly and it's difficult, but we can't basically run to the Supreme Court when we don't like a law and then run away when we do. Once you run to the Supreme Court shuts down democracy. So the right place to have that debate is in Texas. The right place to have that debate is in Florida. The right place to have that debate is in New York State, in California, where we can say, what is the right way to actually protect against the enormous power of these companies? And it's got to be that part of that includes non-discrimination norms. That those non-discrimination norms are sort of central. Because if we say, oh, you can regulate, but not require them to take all comers equally, we're basically taking the most important tool against centralized power we've ever had. The most important anti-monopoly tool is non-discrimination, followed by antitrust. But they're not like either or. It's you need both.
So if I could just respond, I think respectfully, I'm not living in a fantasy world when I recognize what the First Amendment says and how the Supreme Court has interpreted it. Now we can disagree about whether that was correct, but I think also there's a separate and apart from the legal thing, there's a real practical question here is how does a service comply if New York, California, Florida, and Texas all pass laws that say you have to treat the exact same content online, your content, differently, right? So how does a service comply when Florida says and labels certain content like conservative viewpoints, political speech, but then California passes a law that says that content is hate speech and has to be removed? And so then what we're going to get is a patchwork, perhaps 53, depending on the jurisdictions that you want to count, different states saying 53 different things. And so as a practical matter, I think what Zephyr has characterized as running to the Supreme Court is setting a national standard on the internet. And so I think the question is who should be the party that actually ultimately decides that question in our democracy. One of the players is the Supreme Court.
Can I just clarify then? Would you be okay with these laws if they were passed by Congress?
No. I mean, I think the question is, are the laws consistent with the First Amendment? Uh-huh. And so I think there's a way where actually Zephyr and I agree is that the court can decide the issues about Florida and Texas without reaching as far as Zephyr fears and saying that Congress and the states have to get out of the game entirely. And I think, I think there are ways to do that, and I think we saw a plurality, maybe 5, say that they could do that. I think we view the argument differently, but that was sort of how I came away from it, is I think they can answer these questions without actually removing the state or the Congress from the game and just saying that these particular types of laws are unconstitutional.
I mean, just to be fair, if the Supreme Court, the way in which the Supreme Court decides this, and I know this isn't the law class, but it's one of those areas where the weeds matter. The way in which the Supreme Court decides this matters enormously. Where if they find some way, I think the cases are premature. They should wait till the laws go into effect and then come back as applied. And I think there will be unconstitutional applications as applied. Yeah, I can hear Paul being like, okay, less law. we're gonna keep this. But if the Supreme Court basically says there's something really small and detailed about the exceptions in this law that make it uniquely problematic, for instance, then we continue. The real area where Aaron and I disagree is, and correct me if I'm wrong, Aaron, is I don't think the Supreme Court should, I would consider it expand, he would say reaffirm, but expand the protections of the San Francisco Chronicle to Instagram. It's not a newspaper. There are unique rights and privileges of newspapers, and newspapers are responsible and liable in all kinds of ways that big platforms are not. So the area where we deeply disagree is I don't want this court, and we're all counting votes, it's 5 or 4. I don't know, Aaron. I think there'll be 6 different opinions. That's my only bet, is there'll be 6 different opinions. I don't know what they'll say. But I think the danger of sort of giving the beautiful, almost sacred newspaper glow to TikTok and Meta, to these organizations that are clearly just about profit maximizing and maximizing engagement, is, to go back to where I started, a real disaster for corporate power. To Aaron's question about the states, I mean, cry me a river. Tyson Foods has to figure out in each state what the different price gouging laws are. That's the way it works. And I am glad that states are racing on economic issues and on other issues to reclaim their power to organize their economy in the way that makes sense.
Let me interrupt you for just, let me interrupt
Yeah.
you just a second so we can say thanks and goodbye to Evelyn.
Thanks, Evelyn.
Good to see you. All right, thank you.
Thank you so much.
So let me pick up on that. You can have different food regulations, and it's no doubt a pain for national food distributors, but they can comply. How does it work? And this is a pragmatic question for both of you. How does it work when different states, if we have your 100 flowers bloom or 50 flowers bloom, how does it work when different states have different regulations, some of which are likely to conflict with each other?
I mean, there's a recent Supreme Court case about this, pork producers. And in that case, it was about sort of more traditional consumer protection. And you could imagine instances in which the extraterritorial reach was so great that that was a separate ground of finding a problem on a state law. But the truth is, if you can identify state by state rules on taxes, an area where Amazon has flipped back and forth whether or not how to comply with different state taxes. There are practical considerations, and I don't think those practical considerations are trivial, Paul, but I don't think they should be considered of a piece with the First Amendment hammer.
Do you want to respond to my question?
Yeah, so Paul, I think that one issue that we're dealing with is scale. Every minute, YouTube has hundreds of hours of video uploaded. And so a regime in which YouTube has to treat all of those differently, I think is a real substantial burden. And so it's not just complying with how do we organize our business, how do we make sure that our accountants and our business offices understands which various laws. It's actually, we're going to have to make a choice about a particular piece of content, right? At the scale of vastly different than even the content moderation. So all of these services, right, employ both automated tools as well as a team of individuals who review content that's been flagged as violating the terms or perhaps being illegal. We're now going to have to make choices about every piece of content to see whether it complies. So what that's going to lead to is either a fragmented internet in which certain content is just not going to be available or seen in certain regions based on these laws, or it's going to be so burdensome that the only types of companies that can comply are the 5 biggest companies that are currently in power. And so I don't want a legal regulation that reifies the corporate dominance and power. Instead, I would like a tool that actually dismantles that power and decentralizes things like content moderation. And so I think that's the danger. Is I just disagree with Zephyr that I think it's not just a practical problem in which we can sort of say, well, cry me a river, goodbye. It actually has consequences for every piece of user-generated content at a scale that we actually can't comprehend.
Do you want to say a word in response, Zephyr? Then I have another quick question.
Yeah, I think it's an area where we actually have a fair amount of agreement. And we would disagree on this law because I now I'm getting boring, but like, I don't think the court should strike this law down on First Amendment grounds. What I think practically would happen actually with both Florida and Texas is it's quite possible that with those laws that I'll put it a different way. A lot of the problem with the way that we talk about those laws is none of us have any idea what's going to happen. And so the questions Paul raises are very real ones. And to me, the right way to deal with those real problems is wait until they're implemented. I would not be at all surprised if the Florida or Texas legislature repealed some of those laws because they're ill-considered. Their practical implications are hard. Services might leave and then people will want them back. So all those things might happen. And so the right way to deal with those very serious concerns are to wait until it's as applied. So I don't think those are trivial concerns. I just don't think those are the sort of key First Amendment concerns. And I do worry that, and this is maybe less true for EFF, but a lot of people who support the big tech companies in this litigation are using the Supreme Court to enforce policy preferences as opposed to thinking what it means to have a First Amendment right. And I just think we have to keep separating those out and have the policy debate at the policy level, not at the Supreme Court level.
Let me ask one more question, and then members of the class or auditors are welcome to come to the mics and follow up. Are there cases where what purports to be a non-discrimination regulation actually discriminates against certain viewpoints, where the guise of a non-discrimination regulation really is viewpoint discrimination as a pragmatic way?
Yeah, well, I mean, the Texas law in particular says essentially they equate a person's viewpoint as being the same as sort of the immutable characteristics of an individual that we generally think of, remember in that bucket that Zephyr described as sort of the traditional non-discrimination, so sort of race, gender, sexuality, ethnicity. And so what the Texas law tries to do in effect is say that a political viewpoint is a protected characteristic, which I think just at the outset, one observation is I don't think our political views are immutable. I mean, hopefully the whole purpose of this class, right, is to show maybe the poll will change, maybe not, but at least maybe there's some mutation there, right? Maybe we have changed and evolved. So it's not quite the same to me as sort of those immutable characteristics. And so I think that's one of the dangers is when we sort of put these things together, is we're actually not separating I think we're conflating some very different concerns.
So to respond just to what Aaron just said, I do not think they are the same. I do not think that viewpoint is the same as immutable characteristics. And so I was not suggesting that they should be conflated, rather that I wanted to sort of lay out an array of kinds of non-discrimination laws that move from immutable characteristics to your telephone company. And then to point out that there's actually a significant body of law that governs the non-discrimination on viewpoint. One of my favorites is in the ag arena. The Department of Ag is finally moving on this, but in the 1920s, farmers were very worried about the power of basically big meat packers treating different farmers differently. and they have a non-discrimination rule. And there's these farmers out there the last 30 years saying, hey, if I join a political organization, I get paid less. Or I get kicked out of being able to use the meat packer. And it looks like there's new regs that may actually do something about that. I use that not because it's the most important, it's very important to farmers, but it's an example of how when there's centralized power, it is especially important to have non-viewpoint discrimination rules for democracy and for equality reasons. So, Paul, I think the question you asked is there can absolutely be non-discrimination laws or things that call themselves non-discrimination laws that are in fact, don't ever believe a don't ever believe a lawmaker, no matter, just because they call it a non-discrimination regime. Don't believe that. I think the particularly tricky area here that's genuinely tricky is that algorithmic amplification means that this is a simple version of it, but the most toxic content gets amplified. So a non-discrimination regime that doesn't do anything about algorithmic amplification. This is my hand. These are 5 viewpoints I have. They're all about what happened to the bridge in town. One is really, really spicy, rude, toxic. That toxic one is going to go up, is going to be far more amplified. So it looks, where there's no algorithmic amplification, it looks like non-discrimination, but with algorithmic amplification, the effect is that highly toxic, often racist, harmful content is actually promoted. And this is why I don't actually support the Texas version of the non-discrimination regime, while saying that the Supreme Court should not be able to say, states, you can't use what are in fact, you can't use non-discrimination laws. So I do think it's a particularly tricky area given algorithmic amplification, Paul.
Do you want to say a word about that, Aaron?
Yeah, I agree with Zephyr that algorithmic amplification and like discrete harms and sort of the ability of that algorithm to change public perception, to provide users with material that might be harmful is a serious concern. You could call it a compelling one in the sort of doctrinal sense of the First Amendment. I think the question is what's the intervention, and can are sort of these sort of anti-discrimination rules, are those the ones that we want to pull on to deal with this particular problem? And we just disagree about whether that is the mechanism to actually solve them.
So at this point, will some courageous member of the class ask the first question? Yes.
Hello, Professor Teachout. Thank you for your time. Racial segregation in the public schools of Topeka, Kansas was a majoritarian outcome. If majorities always got their way, burning the American flag would be illegal, as would sodomy in many states. My question is this: what is the purpose of the Bill of Rights if not to take certain questions out of the reach of majorities? And what is the purpose of the Supreme Court and judicial review if not to restrain majority passions when constitutional rights are at stake?
Thank you so much for the fantastic question. So I think the purpose of I'm trying to remember your beautiful phrasing, but the purpose is to protect those who would not be protected by majorities. And in this case, not just in this case, in the long line of cases since 1976 on, what we in law sometimes call the Lochnerization of the First Amendment. It's a referring to the way in which the First Amendment has become a corporate tool to expand corporate power by granting corporations First Amendment rights. Sometimes it's directly, and sometimes it's by saying, as in Citizens United, the argument was that the First Amendment rights of the public were harmed when there were anti-corporate laws. I see this whole line of cases as being actually anathema to the sort of the best and highest purpose of judicial review in the First Amendment, because it is actually taking from the public sphere and granting to corporations a set of powers. And so it actually is doing the opposite. It is actually increasing inequality, as Citizens United, increasing corporate power and corporate domination, and increasing the threat that, as we saw in the 1880s and 1890s, that private companies discriminating extended basically radical suppression of the Black vote by 40 years because of the ability of credit providers and landowners to use private discrimination to basically suppress power. So I really see the grant of corporate power as anathema to that core value that you're talking about. But thanks for such a terrific question.
Aaron, do you want to respond too?
I just say briefly that that the First Amendment questions here are about the platforms that actually host and distribute our speech, right? So none of us generally have the technical resources or the financial resources or ability to host our own speech disseminating platforms. And so as much as we are talking about the rights of these intermediaries, because those are at issue in these cases, we're also talking about individual users' rights when it comes to their ability to speak online. So I think it's a mistake to categorize these fights as being synonymous or being the same as fights like Citizens United, because the speech that's at issue is actually our ability to participate in the democratic form of the internet. And so that's really the core issue in my view.
Aaron, would you say, sorry, Paul.
No, go right ahead.
But Aaron, I mean, in Citizens United, it was this argument was essentially the same. It's like it was the right of citizens to hear. It's a right to hear case. It's often described as a speech like granting corporations the right to speak, but it like the core of it is a right to hear case. It's saying that the right of the public to hear corporate viewpoints. And this seems to me to be as a different version of the reflected glow. We're basically saying, oh, because users have rights, that means that corporations, like, let's just be clear, that means that corporations, at least in this non-discrimination area, can't be regulated.
Well, I don't think it means it can't be regulated, but I think what the corollary to that is that if the government has the power to place liability on the platform that's hosting your speech, the intermediary that distributes be increasingly less likely to distribute your speech. So it's not just your right to receive the speech of your friends on social media, it's your right to speak at all on a platform that gives you unprecedented reach compared to any other media that we've had previously. So I do think it's just different.
But there's nothing that ensures your right. I mean, I guess that's the key, is that when we are actually granting rights to these platforms, they can choose to suppress, as they consistently have, Black creators' voices. You know, there's a lot of evidence on Black Lives Matter being suppressed. It isn't actually a granting of rights to those individuals. That would be a different matter. It's literally a granting of right to the platforms to do things. And there was another moment in the oral argument where there was like, could Google basically be racist in its search results? And NetChoice had to say, yeah, because it's a granting of power not to the public, but to the platforms themselves, and a kind of a hope that they will continue in an even way. I mean, continue may be too optimistic, but it's not actually a direct granting of power. I do think that's really important.
Well, I mean, I think we disagree, and I think this goes back to something you said earlier about how this idea of like newspapers or media, more traditional media, having sort of a role, like whether that's an ethical role or just sort of a normative role. I would say that the history of media itself and their rights that we have, in your view, granted to them shows that they can do the same sorts of abuses that you just described. And so for every example of a sort of noble media, there are many that have done things much in the similar way as you just described. And so I don't think it's right to say that we should treat these platforms differently because they're behaving irresponsibly or perhaps even wrong. I think they're engaging in the same sort of practices that media before them have done. And so I think we're just going to have to disagree there.
Go ahead,
Sorry,
and
go
then we'll
ahead,
take
Paul.
another question. Finish, Zephyr.
No, I just, when I was talking, I don't know if I told you this, I don't think I did, but I was talking to take your point, but in the opposite direction. When I was talking to one of the giants of progressive law in the 1980s and 90s, Owen Fiss, about this case. And I said, I was telling him I was going to write this brief. And I was like, I think, there's this case that says that shopping malls can't discriminate on the basis of viewpoint. And I said, I think social media is more like a shopping mall than a newspaper, at least. And he said, a newspaper is more like a shopping mall than a newspaper. He was basically saying, look, corporate media, we can't trust them anyway. But just to give you a sense, which is so interesting, of the other way to go with your argument is to say the 1970 case giving newspapers a special role was wrongly decided. But let's just a little anecdote. Let's go to the next question.
Meant coming from somebody who probably never uses social media, I'll bet. Over here.
Yeah.
Thank you both so much for your time. Hearing your opinions on the judicial matters in this discussion has been super fascinating, but I'm interested to hear more on your legislative opinions. You both agreed, I'm pretty sure you both agreed, that the Texas and Florida laws were bad in addressing the concerns that you both have. So I'm curious to hear what, to your opinions, would a good law regulating kind of social media activity would look like. Just to give an example to guide the conversation, that on immigration topics where it's important to have a discussion of immigration, but sometimes such discussions can get implicitly and explicitly racist. How do you allow those discussions to exist and be had while preventing them from being racist? So what would your recommendations be on legislation to go about doing that?
You want to try this first, Aaron?
Yeah, I think that's a really, really difficult question, is how do you design a law that enables, I think what you're talking about is it enables sort of a space where civility occurs and where we have some real ground rules that say, at some point in time, this conversation has gone from being sort of a good faith debate to one that is explicitly racist, right? And so I think the hard part is, how do you design a law that actually encourages, I think, the result that we want, right? Which is the moderation of the discussion so it doesn't go off the rails, without actually making it so that the intermediary that's hosting that discussion is so afraid of liability, either because the content itself is going to hold them liable, or their failure to moderate the content is going to hold them liable, that they don't actually allow that conversation to take place. And so I think the other, not to complicate it further, but the other tricky thing is, unfortunately, there is a host of racist content online that is protected by the First Amendment. And so I think that's another wrinkle, is how does a state write a law that actually encourages the moderation of content that's not itself illegal, that's protected by the First Amendment, but that we would agree is generally awful. And so I think it's actually just sort of a really difficult question to ask. One of the goals of some early internet regulation, if you look at sort of the purpose behind what we know as Section 230, was to actually encourage moderation, so that good faith efforts to restrict content that was constitutional, but that would basically be awful, that the platforms would take steps. And so that law is on the books, and they're incentivized to do that because they're not held liable by like sort of removing content that is legal. But I think the reality is that's not enough incentive, right? And so how do we incentivize it in a way that still actually encourages that moderation, but doesn't actually make it so that the platform's afraid to even host that conversation in the first place?
Zephyr, do you want to say a word on this?
Oh, I love this question. I think it's the most important question. It's actually what I want you all to be thinking about for the next 20 years. and keep moderating if the Supreme Court lets, moderating and engaging. So I have three answers, none of which are sufficient, but I think we're going to have to deal with this in a patchwork way. Somebody said, the social media problem is like climate change. Like we got to deal with it at every single level. It is such a profound problem. I start with one premise though, which is it's absolutely broken right now. I do not think it's working. The particular kinds of conversations you're having, Section 230 has not worked to allow for a civil, meaningful discourse. So I would not hold up the status quo as a model. Here's three different ideas from three different approaches. One is one aspect of the Florida law. I do actually think is quite good, which is to require platforms to comply with their own terms of service in an equal way. And if there's a broad, and I actually, we had a brief conversation, I think Aaron agrees with me on this one. So that I would be very worried that a decision would not allow laws that require fair, consistent compliance with your own terms of service. So we were talking about issues related to Israel-Palestine, that whatever is taken down in a consistent way, and failure to do so is a legal violation. So that's one. Two, I'm working on legislation in New York that California is also going to sponsor. In New York, we'll know in a week whether it passed. I think Kentucky might have it too. It's in child social media. And the legislation would ban targeted content, basically ban the use of personally identifiable information, understood broadly, any inference about you, to deliver content. With the idea being that both addiction and the TikTok, Instagram mechanism is extremely bad for kids' mental health. It's an addiction mechanism. I sometimes think about it as amending gambling laws to apply. That's a non-discrimination regime. That's a different form of non-discrimination. A third, where Aaron and I are definitely going to disagree, is I think Section 230 should either be amended or interpreted when we finally get the Supreme Court to interpret it, not to cover promoted content. So that Section 230 basically granting broad immunity with the presumption that something is a neutral platform, but not promoting, amplifying. If content is promoted, it loses the protection of the immunity. I don't know. I mean, by the way you asked, I suggest to me that you know something about these issues, but I use those as three micro examples of ways in which we could start to kind of relearn the muscle of saying we have a major problem with immune centralized power. I mean, we're talking kingly power here. And we've got to chip away at the immunity, at the capacity for discrimination in these different ways. So those are three areas that I think are really important.
Before Aaron responds, maybe I'll turn to you and Would you summarize Section 230, because not everybody in the class knows it?
Sure. What Section 230 says is it says two things, essentially. So it says that a provider, an online service that hosts user-generated content is, subject to some exceptions, not liable for that content. It's not treated as though it were the publisher of that content. There's a whole backstory about publication liability, but all you need to know for basically is that when you post something on Facebook, if you have defamed me, you've said something defamatory about me, I can't sue Facebook. I can only sue you. The other provision of Section 230 says that the provider is not liable when they make good faith efforts to actually moderate your content. So when they remove your content, when they sort of make sure that it's not circulated and all those sorts of things, you can't sue them under some legal claim for that. And also basically that their efforts to their knowledge of that content and their efforts to restrict it can't be used as sort of a basis for liability. So that's what Section 230 is. On Zephyr's point, on the point about consistency, a caveat and just sort of a clarification. The caveat, I'm speaking for myself when I talk about this and not for EFF. But then the qualification is it's a qualified yes in terms of the consistency that I would think would survive a sort of First Amendment challenge is the idea that the platform enforces the policy that it has at that moment consistently. I think the platform still should have the ability to change their rules and indeed be responsive to things when they get it wrong. So one of the problems of sort of you must have consistent rules and you never change them and must apply, and this is not what Zephyr's saying, just to be clear, but I just want to clarify, is that essentially you're sort of tying yourself to the mast of a potentially like problematic content moderation policy. And that actually, I think, eliminates the ability for the public to actually persuade a service to change those terms if they have to sort of maintain those terms over time.
We have one more question.
Yeah, hi. Thank you so much for talking with us. My question is about, you both kind of, maybe you agree on there should be power to the people when regulating social media. But I think something we've seen with social media and like the algorithmic enhancement is like, it can be a place of echo chambers and people see what they want to see, not so much what's best for them to see or what is going to like teach them the most. So do you think like the power should be in the hands of these people? Like how do we manage the uneducated masses just falling into these kind of echo chamber traps in this whole conversation?
Yeah, I mean, I think that's a really challenging question. And so, from my perspective, the way that you handle that is you actually give people more power to actually control their experiences online. And so we move away from the platforms controlling it and we enable users. And so that would be through the development and creation of tools that can actually interoperate. So you can choose the tool that you would like to use and actually better manage your feed in a way that is transparent to you about how information is presented to you. And then you can make choices about the type of information that you want to see. And I think one of the difficulties here is in some ways these echo chambers, are they the product of the platforms? Are they the product of user choice? I think it's sometimes a mix, right? But if you can at least remove the platform and make sure that it is the product of the user choice, I think that actually helps in a lot of ways and can address some of these issues. At least to a point where I think Zephyr and I agree about like, the sort of algorithmic content in which the most sort of engaging or awful content is what is surfaced and circulated because of the ability for engagement. If you had a tool that you could actually sort of say, I don't want to see that information, or I want to see it in a digest at the end of the day, and not like the second it comes across my feed, I think those types of tools can go a long way to helping us.
Zephyr, do you want to say a word?
Yeah, I think it's one of the hardest questions and one of the most important. And I think you won't be surprised that even in Aaron's answer, you can see where we're going to have a very deep difference. I don't think consumer choice is ever going to be a way to get there. I do think that consumers should have a lot more power. And banning discriminatory practices is one way that I shouldn't even say consumers, the public can have more power. Another way is enhancing the relative power of news organizations by forbidding discrimination between those news organizations. The prior questioner was asking about legislation. I do support the JCPA, which by some estimates would put $11 billion in the hands of news organizations, which then have the heft to provide like at least multiple fact gatherers who are producing investigative stories that you can call on. But as we're thinking about legislative change, I mean, I've been very focused on our New York bill. It's only for under 18, but I think it raises questions for every age. Is algorithmic amplification? It's kind of design. It's a product design. How much do we allow it? Like, can we think about it as defective in some contexts? And the more that we can, I keep talking about this, but sort of regain the muscle, as long as the government is not discriminating on the basis of viewpoint, which I don't want it to be doing. Let's regain the muscle to understand these are technical design questions that we can say, hey, you know, we didn't have seatbelts in the 70s and people thought it was a core freedom issue, but we came to understand that it was a problem of defective design. So is algorithmic amplification itself and the echo chambers that you're talking about, which I think is such a significant democratic problem, something that we can address through design regulation. Anti-discrimination laws are going to have to be part of that. They're not the whole story, but they're part of it.
Thank you so much. Before we thank you and let you go, Graham is going to do the poll again.
I don't get my final.
Oh, absolutely. You're absolutely welcome to have a final say, both of you.
I know you want to get a final word in, so go ahead, Zephyr.
No, I can go ahead. Yeah. All I want to say is, I don't know if you guys remember, but we're really talking about who's governing us here. And do you remember in 2020, you probably, I don't know what ages you were then, but there's this great group that I love to work with, Color of Change, that organized a boycott. On the basis a boycott of Facebook on the basis that Facebook was basically promoting a ton of hate speech, sort of failing to address really problematic content. It was called Stop Hate for Profit. Coca-Cola, Adidas, Nike, I don't know if it was Nike, I forget, Best Buy, but like over a thousand companies got involved to try to stop it. Nothing happened. Nothing happened. We are not going to govern big tech companies through boycott. Those days are just done. We are not going to do it by, getting off Instagram for 2 weeks because you're mad about a decision. I get it that public governance is really difficult, but we're not going to govern it well by turning it over to Alito. I really think that we have to sort of do the hard thing and answer the questions that the last two, I want to say callers because I can't see you, the last two students are asking, but do it collectively and not turn it over to the court.
Thank you. Aaron, do you want a last word?
Oh, I would just say that I agree with Zephyr that we need to wrestle with these hard questions. I think one of the problems is these questions are presented in really sort of awful cases or awful sort of policy pieces, right? The Texas and Florida laws, we agree, are not models of clarity or even good governance. But I think, hopefully what you walk away with is like EFF is engaged and actually is regularly engaged with Zephyr and her work on these issues. And we do want to be good faith partners in trying to deal with this. We just come at it from a perspective of some of these things we think are going to run into significant First Amendment problems, and not just in sort of an abstract deregulatory Lochnerism sense, but in the sense of like they're going to harm users' speech. And so that's where sort of we come from. But yeah, thank you again for your time.
So while Graham puts up the poll now, let me say while he's doing the poll that my own vote didn't change, but I became much more confused. And I regard that as a plus. I think when one gets confused, that's the beginning of then figuring out how to unconfuse myself. Oh, let's see how this has changed. We now have, what's the percent?
About the same.
61% yes, 38% no. So some shift.
Yeah.
Let me just say two things. One is, it's very seldom that we have a dialogue of this sort where you're going to see not the right answer, but an answer, a definitive answer, for better or worse, within a month or two. But secondly, let me just say this, from my mind, this was just a fantastic conversation the two of you had, not just in terms of substance, but the wonderful way in which you listened and responded to each other. So thank you both very much, and just thank you.
Thanks,
Thank you,
Evelyn.
Paul. And thanks, Aaron, for cultivating confusion.